The chair recognizes the distinguished gentleman from Virginia, the chairman of the full House Judiciary Committee, for his opening statement.
Mr. Chairman, thank you very much, and thank you for holding today's hearing. This hearing concerns matters of critical importance to American taxpayers and all who rely upon our federal courts to adjudicate their constitutionally protected rights and dispense justice. We are joined by a distinguished panel of witnesses that includes 2 Article III federal judges, a dedicated and professional employee of the federal judiciary, and the Deputy Commissioner of the GSA's Public Buildings Service. The purpose of today's hearing is to begin a public examination in this committee of long-standing issues between the GSA, which is charged with managing the federal civilian real estate portfolio, and one of its major tenants, the federal courts. This examination is urgently needed because the subcommittee is charged with the responsibility of ensuring that our federal judiciary has the ability to perform its constitutionally required and statutorily directed responsibilities. Essential to the performance of these duties is the ability to operate in safe, secure, and sound physical spaces, whether in a standalone U.S. courthouse or in a multi-tenant federal building. In some instances, including the example of the PA Federal Building in Roanoke, Virginia, the GSA has abysmally failed in its mission to provide superior workplaces for federal customer agencies at good economies to the American taxpayer, which is their mission. This hearing builds on one conducted in April 2011 under the leadership of Chairman Schuster and then Subcommittee Chairman Jeff Denham of the Committee on Transportation and Infrastructure's Subcommittee with jurisdiction over public buildings. That oversight hearing directly examined whether GSA's mismanagement and execution of contracts for the greening and modernization of the PA Federal Building violated federal law and led to taxpayers being charged excessive amounts for the work. At that hearing, which occurred before GSA had broken ground, GSA's own Inspector General testified, and I quote, "GSA has an obligation to spend the taxpayers' money on sound, well-thought-out projects that make the best use of taxpayer dollars. Our reviews show that GSA does not always meet this obligation and did not do so here at the PA Federal Building." The IG found that the GSA had failed to get an independent government estimate for construction as required by the federal acquisition regulations and violated federal law in awarding the construction contract by advertising the guaranteed maximum price the government would pay. As a result, each of the 10 bids received were identical and, unsurprisingly, at the maximum amount. One direct result of GSA's violation of federal law was that the IG recommended the agency not exercise options in the contract that would have improved the building's security and led to building code and life safety improvements. Startlingly, this is one recommendation that GSA was more than willing to follow. Also testifying in April 2011 was Ms. Julia Dudley, the clerk of court at the PA Federal Building. Ms. Dudley correctly anticipated a number of impacts on the court, noting the ability of court employees to perform their duties would be negatively affected by repeated moves, losses of space and facilities, shifting of burdens onto court personnel, and even disruptions to court security systems and IT infrastructure. Notwithstanding the public shaming of GSA and repeated concerns expressed by public officials, including myself, Senators Warner and Webb, and court officials regarding GSA's justifications, decision-making, and management of the PA renovation, GSA refused to alter its course in a manner that would have improved the value received by federal taxpayers or the ability of its federal judiciary tenants to perform their duties. Since that hearing, GSA has declared its work at the PA Federal Building substantially complete. The project, which was originally budgeted at approximately $51 million, has already cost taxpayers in the neighborhood of $65 million, and GSA is requesting an additional $17 million. A large portion of the initial increase is attributed to the GSA's failure to anticipate the need to move the Veterans Affairs Regional Office out of the building for 3 years. That failure to plan cost taxpayers approximately $11 million while imposing incalculable costs on Roanoke Valley veterans. In addition, GSA claims to have not foreseen the need to replace 2 14-story brick walls that began to collapse in 2012, threatening the safety of court employees and the public and causing the court to shut down for a week. That condition is now estimated to cost $6 million to repair. Notwithstanding GSA's lack of foresight, it turns out the agency had repaired the wall once before, but it evidently did so in such a negligent manner that it posed a danger to life and safety, at least while the building was undergoing a major renovation. Mr. Chairman, I request permission to enter into the record an article entitled "Bricks Try Patience of Court Workers at the POF Building," which was written by Lawrence Hammock and published in the December 2, 2012 Roanoke Times. The article describes some of the impact on the court of GSA's mismanagement of this project. According to the GSA, federal courthouses comprise nearly 1/4 of GSA's owned portfolio. That percentage contributes an enormous amount to GSA's bottom line, the rent it collects from federal tenants. While I am disappointed in the testimony of our GSA witness, I am not at all surprised by its non-responsiveness in refusing to address the particulars of the two cases before the subcommittee today. The POF case and the expenditure of $3.4 million to win a landscaping design award at the Domenici Federal Courthouse in Albuquerque, New Mexico, when all that was needed was a fix to a simple leak, are inexcusable. If I were called to defend the actions of my employer in violating federal contracting law and repeatedly failing to prioritize security and life safety improvements over other projects, then I wouldn't want to defend those choices either. These cases are symptomatic of a larger problem, though. GSA's arrogance, refusal to consult and engage in meaningful pre-project planning with local court officials, inability to perform projects on time and on budget, and the lack of qualified on-site supervision not only costs taxpayers an enormous amount of money, it also shifts costs to the judiciary, jeopardizes the safety and security of judges, court employees, and the public, and impairs the essential duties of federal courts to perform their constitutional duties. Our GSA witness can paint a rosy picture of the relationship between GSA and the courts, describing it as a close relationship where projects are jointly prioritized and joint efforts are made to improve planning and drive down the overall cost of the judiciary's space needs, but he and the members of this committee know the truth. The judiciary does not have joint responsibility for determining how its space needs are met, nor do they have control over the rent GSA collects. The two projects we focus on today are likely the tip of the iceberg. Since announcing this hearing a week ago, we've received reports from several judicial districts around the country that involve similar concerns about GSA's ineptitude, incompetence, and lack of responsiveness. As an example, Mr. Chairman, I ask permission to enter into the record 4 documents that were received yesterday from the Honorable Ada M. Delgado Colon, the Chief Judge of the U.S. District Court in the District of Puerto Rico. Judge Colon describes a situation where GSA has taken 2 years to determine a method to terminate an allegedly incompetent contractor and jeopardize the completion of a project that costs more than $99 million. According to Judge Colon, our GSA witness today, Deputy Commissioner Michael Gelber, has known about this situation for some time, and yet, to date, progress continues to lag. And 2 days ago, the Director of the Administrative Office of the United States Courts sent a memo to the Chief Judge of all United States Courts, the Chief Judges of all United States Courts. The memo states in part that the Administrative Office and the Judicial Conference's Space and Facilities Committee have long been searching for a way to hold GSA more accountable for the services it provides to the courts for the more than $1 billion in rent the judiciary pays to the GSA each year. Disagreements on the rent GSA charges the judiciary, on project delivery and estimates on overtime utilities and on space assignments and billing validation have been long-standing issues." End quote. Judges and local court officials are clearly thankful that this subcommittee is seeking to hold GSA accountable, and many are approaching us anxious to tell their stories of waste, arrogance, and indifference at the hands of the GSA. In addition, I want to inform the members of the subcommittee that the Government Accountability Office is conducting a systematic review of all courthouse projects undertaken by GSA under the authority of the stimulus bill. I'm pleased to report that Chairman Schuster, the chairman of the Committee on Transportation and Infrastructure, which has direct oversight over GSA's operations and management of the federal civilian real estate portfolio, has joined me in the effort to study GSA's mismanagement of the billions expended pursuant to this authority. In a very real sense, GSA's mismanagement of court facilities imposes a hidden tax on the operation of our federal courts and impedes American justice. I thank the Chairman for conducting this hearing. Notwithstanding the GSA's continuing efforts to obfuscate and evade responsibility, I welcome today's hearing as a step forward in holding GSA and its officials accountable publicly for their conduct. Thank you, and I yield back.